with our meeting. Hopefully you all have the agenda, and then you've received the email from Krista with the attached documents that we've received for this meeting. And so we will go ahead and follow that agenda. Of course, first, thank you all for being here. I think what we'll do today is we're diving into a new area of our bill, talking about what is appealable. That's our third agenda item. But before we do that, we're going to start by having a quick review of where we are right now. And so we're going to take reports on sections that we've previously discussed, or subjects that we've previously discussed. And the first one of those will be the jurisdiction section, which was section 1. And we had a smaller group headed by Jim Nass working on that. And this larger group hasn't gone back to hear what the status of that is, Jim. And so maybe you could just take a minute or two to bring us up to date on the group's effort with respect to whether there's anything we can do with the jurisdiction statute or need to do within this group.
Thank you. Respecting the provisions having to do with the jurisdiction of the court, I had proffered a number of amendments in addition to what is in the draft bill in an attempt to respond to concerns from the judges. We went back and forth with a number of versions of that, but ultimately my impression is that we reached an impasse, and that the impression I had is that the judges preferred not to amend section 1 of the would prefer not to have section 1 in the bill at all, and to leave the basic statement of the jurisdiction of justice courts as is. Recently, Judge Brinton contacted me and said maybe we should take another run at it. So the current plan is that we are going to resume meeting in January and see where we can get.
Great. Thank you, Jim, for that report. And thank you, everyone, for your continued work on that section. And then the second part that I just like to summarize is that we have been talking about the process of moving an appeal from the local court here as part of the bill, the justice court, to the circuit court. And we have talked about the filing, where the notice is filing, what needs to be in the notice of appeal, service of the notice of appeal, required fees, and when jurisdiction transfers. And we've gotten feedback on those sections of the bill. That section's all the way through 14. We did ask Lindsay Detweiler of OJD to help us think through what the process of filing that notice would be like if it started either in the Justice Municipal Court or in the Circuit Court. And Lindsay has prepared alternative process suggestions for those options, and those were sent to all of you by email. And we don't need to go through those. I think what those do is lay out alternatives. But if anyone has any clarifying questions that they want to ask Lindsay about those alternative proposals, we can take a minute or two now to hear those questions. And I'm sorry, all but 2 of the screens of your images on my screen are blank right now. So I can't see any hands, and I'll rely on Sandy or Krista to call on anyone. If anyone has clarifying questions for Lindsay.
I'm not seeing any hands, Joseph.
Okay, great. And I can't see any of you. I'm going to try and change my view and see if that regenerates any of these videos. Doesn't seem to. Okay, Lindsay, I have one question. when you have the section that talks about notices of appeal filed in this circuit court, it says under 1, there's a note that the appellant can file electronically the notice of appeal even, and serve the fee waiver or deferral request. Is that correct? So someone can electronically file those initiating documents?
Yes, that's not the current process because they're not filed in the circuit court, but that it's possible for those to be electronically filed through our filing system, is my understanding.
And do you have any information on receipt of payments? Can that be done electronically? Are the circuit courts accepting online payments or electronic payments?
For initiating new cases? Is that your question?
Yes, yes.
Yeah, our file and serve system takes payments when filings are received.
Okay. That was the only question I had. And I do apologize. It does seem like there's something going on my end, which is slowing down transmission. But if no one else has any questions for Lindsay.
I had a question, Lindsay. Sorry, this is Jordan Hubert. The last time I checked file and serve was a very long time ago, but they were having trouble with pro se litigants e-filing. Is that still a thing, or has that been resolved since like the last 7-8 years?
I think my understanding is that pro se litigants can e-file, but I will double check that and get back to you. And maybe we have a TCA that's going to answer this question for us.
Say litigants can only file and serve. Generally, they file and serve through a program called Guide and File, which is a sub-program that allows them to file usually without any payment or fees. Otherwise, to file and serve, you have to subscribe to that system. And most pro se self-represented litigants don't subscribe to file and serve. Those are generally mostly attorneys and organizations. So we would not see very many appeal filings coming from self-represented litigants through file and serve, would be my guess.
Great. Any other clarifying questions for Lindsay?
Perhaps just one I just want to make sure I understand what Lindsay was saying. Is it true that under current law, the statutory scheme is a little awkward in that although the one statute assumes that the filing fee for civil cases violation and for civil cases and violation cases is the same, or that is governed by the same statute. In fact, the filing fee in civil cases is governed by one statute and is in one amount, and the filing fee in violation cases is governed by a different statute and a different amount. Correct. So that's something that we should probably fix.
I think that's right. I think that 21-160 sub 4 specifies the filing fee from an appeal from a justice court in a civil case.
So Jim, do you have a suggestion or that we should make note of?
Do I? Yes and no, but it's more of a policy question. I'm leaning toward recommending that we eliminate the filing fee for violation cases. It just seems to make the process more complicated in that the filing that goes first to the justice or the municipal court for a misdemeanor case would not include a filing fee or a motion to waive or defer, but for a violation case it would. And that's just, and then if it goes to the circuit court without a filing fee and the circuit court rejects the filing, the circuit court doesn't send it back to the appellant, it sends it back to the justice court or municipal court. And it's not clear what happens after that. That there are just so many difficulties with the filing fee in the violation cases that one way to simplify the system is simply to eliminate the filing fee for violation cases.
I don't understand. You said that they would send the filing fee back. The filing fee is non-refundable.
No. The
Okay,
cases where the notice of appeal, cases where the appellant did not tender to the justice court a filing fee or a motion to waive fees, the justice court forwards that onto the circuit court. The circuit court rejects the filing because there's no filing fee or motion to waive or defer, and sends the paperwork back to the justice court.
Well, the justice court should not have forwarded it to the circuit court without the requisite filing fee attached.
Or waiver. Or motion to waive or defer.
Or
I'm
one
not
waiver,
sure.
yes.
I'm not sure it's clear from the statute that you can refuse to do so.
Well, I think if what's required for the filing is not all there, then I don't think that it's appropriate to forward it to the circuit court when the statutory requirements are not met.
and I think we've talked about these issues. This is the filing fee, whether to require it and who receives it. Those are that we are going to have to revisit as we've got the feedback now. We will go and try another working draft which reflects the feedback. We will have to make some decision points there. I think those decisions will be guided by, I think our goals as our goals or our charge is to make the processes for appeal as clear as we can, to make them as efficient as possible, and to avoid creating unnecessary obstacles to bringing the appeals. So I think we've talked about these issues. We have Lindsay's mapped out some potential ways we can revise, alternative ways we can revise the draft. So I think we could say we've talked about those. We'll have to come back with a revised draft, and we can move on to the sections which are about what types of cases or orders or judgments are appealable. Krista, I can now see on my screen. Sorry.
Yeah, I did want to just circle back to one other thing that we didn't have a chance to do or we requested input after the last meeting regarding service on DAs and city or municipal attorneys. And I have been in touch with Melissa Franz and Bill Golden, who I believe are both here, or
I do see both of them, yes.
yes. So I'm not sure if they're prepared to address that at this point or not.
Yeah, we welcome your input on that, Melissa and Bill.
Well, I'll be honest, I'm still trying to wrap my head around the issue, but I think that I understand it. And we're talking about appeals for violations from justice court or municipal court, and the DA in Clackamas County does not handle those. I have reached out to ODAA as a group and not gotten any consensus. I did that through my elected DA as to what they would want. But as I understand the issue is who is the service of the notice of appeal on? I think it would be to the prosecutor of the court from which it came. And in the cases where there isn't a prosecutor, like I don't believe there is one in justice court here, that should go to the officer who brought the charge. and then they would appear in court. The DA would not be appearing on behalf of that officer in a violation, appeal, or trial.
So in the city of Eugene, at least for the municipal court, and I know it may differ in other jurisdictions, but how we are, how the city prosecutor's office essentially represents on violation cases where the defendant is represented by counsel, and obviously on misdemeanor cases. I'm not sure how that works in other jurisdictions. Maybe that the city, there may be a city attorney, but not a city prosecutor necessarily, in those situations. But at least for what our position would be as the city prosecutor for Eugene is that we would be served a copy of the notice of appeal for misdemeanor cases and violations where the defendant was represented by counsel. If it makes it easier, just for, you know, trying to encompass all types of jurisdictions and how they manage, you know, whether or not the city appears on violation cases, probably default is that we just receive notice of appeal for all violations, even though that may be some unnecessary paperwork coming our way. But I would say that that would be our position. I would also say for city of Eugene, we have a city attorney and a city prosecutor's office. Our city attorney handles generally the civil litigation, and we handle the sort of criminal violation piece. Sometimes they can be involved, but I realize that generally speaking, the statutes refer to city attorney. Usually it'll find its way to us if it is sent over to the city attorney. But I don't also see any harm in just adding verbiage that says city prosecutor or something along those lines.
Just taking some notes. Any reactions to that information?
I guess what I'm struggling with, as I recall, the current statute requires service on the city attorney or the district attorney, not the police officer. And so we would be making a change in current law. And it's not clear to me how the defendant would determine the address of the police officer.
I think it's pretty easy actually to find. I think we could do the office of the prosecuting officer. If we are, my sense is this group is moving toward a consensus perhaps around no filing fees for appeals, which mean there will be a lot more appeals, is my sense, right? Not from people who could not afford the appellate fee before, right? Because they would be entitled to a waiver, but rather from people who can afford it, but think it's not worth the candle. Anyway, so I think we're gonna get a lot more appeals, and the way that people win appeals from justice court by and large is that the officer does not show up. So I think it's fair if we're going to have a lot more appeals that the actual body who is prosecuting the appeal get notice of the appeal.
Yeah, and I wish Judge Zemper was here from court, or at least a representative from court. But when there is no counsel representing someone in the trial, the violation trial, I believe right now the court notifies, and when I say the court, I mean the municipal court notifies the law enforcement agency of the pending appeal at circuit.
And
I don't think we should so quickly say we're moving away from requiring the filing fee. I know I think there's maybe more of a split of opinion than Judge Kidd. I think. Oh, I don't know.
I see.
I for one do not think we should remove the filing fee.
I see Heather and Jordan have their hands up. Heather?
Thank you, Justice Duncan. I don't want to like repeat myself from before, from last meeting, but just thinking again about this broader concern of our group with preventing unnecessary obstacles in the process. My experience with my clients is that there's often a lot of confusion about various agencies that they're interacting with. And I think sometimes we take for granted, because of our knowledge of the system and the various actors, how difficult it is for members of the public sometimes to like make those distinctions. And I know for me, it would be very easy to figure, well, I shouldn't say that, but it would be much easier for me to figure out who to serve than it would be for my clients. And I remember from last meeting, someone pointing out that in some jurisdictions there could, and correct me if I'm wrong, but I'm recalling there might be dozens of different agencies that might be implicated in various proceedings. And that sounded particularly confusing. And so this change from the current policy, which it's unclear to me what like the degree of the problem that we're trying to solve with this change. But I think it would create unnecessary obstacles for pro se litigants. And so I would urge not having this change. But if we were going to have a change like this, creating a process where the court will tell the person who that agency is. And I know some courts were saying they already have lists and maybe that wouldn't be so difficult, but just having some mechanism there to make it crystal clear to the party who they're supposed to serve.
Jordan?
Thank you, Justice. I'll echo what Heather said. I think if our aim is to make this simple, we make it as simple as we can, and just this is where you take this paperwork, this is where you take this paperwork. And the city prosecutors, I think, I'll echo what Melissa said, are in a decent place to be able to forward that on to the people who need to get it if it's not them. I will also say, just while we're on the subject of fees, when I was in private practice, the fee was not the deterring factor from the appeal process for my clients. It was the time it was going to take and the time it would take out of their lives to appear in court. So the ones that had the money were not necessarily be more likely to appeal if it didn't have a filing fee, at least in my experience.
Now, if I can say something, I don't know how to raise my hand, so I can't use the proper protocol. My apologies. But I think if we think in terms of, I think Justice Duncan has stated there were 3 principles. One of them is eliminating roadblocks. But to me, that's an access to justice, which is a term that's been used a lot. And I think if we think in terms of access to justice for citizens as maybe an overriding important point on this, it works better for me. So I agree with what Heather and Jordan have said. Pro se people probably are pro se because they didn't have any money to pay a lawyer. And we'll revisit the on violations. I'm in favor of abolishing that or not requiring that, I think, is the current situation. But if we think of it as an access to justice issue being an important principle here, I think we do better. Thank you.
And I have to apologize, my screen froze and I dropped out. And so Krista, if that happens, I hope you'll just jump in, and maybe you just did that, but it cut out. Things, technical issues today. I see Judge Cross's hand is up. So we'll hear from Judge Cross, and then I have a comment, and then we'll move on to our new section.
Well, I also was in private practice before I became the Justice of the Peace here 7 years ago, in a private criminal defense practice. And I appeals from traffic violations were kind of few and far between, more because of the cost of the lawyer than any kind of filing fee issue like that. And I constantly see in my court all the time people who could easily afford attorneys on violation cases elect not to and to represent themselves. I see it with these are one of the of what I used to call the 3 types of cases which cut across all socioeconomic levels. So it's not that people who can afford lawyers will hire lawyers for these traffic tickets. Most of them won't. So I do think that Judge Kidd is certainly right that we would see a significant increase in appeals as people would again continue to represent themselves and take another shot in the circuit court. That's would be my experience anyway with regard to that. And in terms of the issues within the access to justice, well, that's where again I think courts and many courts need to be better at making sure that we have the ability to assist people with the knowledge and how to seek out a waiver of the fees if they qualify economically. We certainly do that here in my court, and let them know where they have to go and what they how they have to do it, what the timeline is to get it done. So those things all exist here. We're not denying that to anybody.
I see Bill's hand up, and Bill, why don't we hear from you on this, and then I'd like to suggest that maybe there's some brainstorming and some information gathering we can do on this service issue in between now and our next meeting, and then we'll move on to our new sections. So, Bill.
Thank you, Justice. I think my point is this to be made about the service of process, and I understand all of your arguments. But if the part of the service of an appeal is to the district attorney who's not involved, you're asking us to take on yet another responsibility to then forward it to some agency or other agency. I don't believe it's that difficult to figure out who cited you when it's on the ticket. I don't think it's that difficult once you're in court to figure it out. And I do believe that courts could do that if they're already prosecuting or processing paperwork with regards to notice of appeal, that they could forward it to the right agency. And it would be simple just to forward it to the agency and let the agency figure out which officer needs to be notified of that.
And
since the district attorneys are largely not involved with this process, you're creating another obstacle in that process in delay of us receiving something and then trying to forward it on to someone else. So that is the point that I was trying to make.
But Bill, that's not being created. That's the way it already is. That's the way it already is and has been for decades and decades.
So I think what I see, I've got 2 more hands up. We will get to those, but I hear what I'd like to suggest is that over the next little while, as these cases are coming into your courts, whether you're the lawyer or whether you're the judge, just keep an eye on, is there an easy way? Is there a notice of appearance that's filed? Is there some sort of, do your judgments reflect who appeared? Is there some sort of documentation that already exists that's going to reflect who the person to be served, who's the prosecuting entity, the representative of the prosecuting entity? Do you already have that information readily available? And does it show up somewhere that any appellant would have easy access to? Because if that's already happening, then we can design a process that tells people to serve that person. And that will hopefully accommodate all of these different possible agencies. So that's something we can keep an eye on. And before we close this, I've seen Melissa, and it just says Pal J. I'm sorry. Trial Court Administrator Pal. So on my screen, Melissa, just first, do you want to?
Yes, thank you, Justice Duncan. While we were sort of sitting here, and I know we want to move on from the filing fee situation, when we talk about access to justice, I just want to make sure we recognize it from the opposite side as well. If we have an influx of violation cases just for the sake of filing violation cases, that dramatically reduces the time judges have to hear other matters like protective orders. And so I just want to make sure that there's a reason those filing fees exist. It's not just workload, but it's also to prevent folks from filing, I would say, maybe some things that aren't as colorable as they may seem. And so I just want to make sure that we're thinking about it from both sides of access to justice. So just wanted to put my 2 cents out there.
And then Mr. Powell.
So I just wanted to point out, and I'm speaking from my experience in Klamath, but I can't speak for all the circuit courts. When we receive an appeal from the municipal court or the justice court, and we prepare that filing in Odyssey, we set a trial court date. And when we set that trial court date, we serve the parties. So service is done when that case is filed. We notify the police officer that a trial has been set.
And how do you get that information? Where are you gathering it from?
It's in the filing, and if it's not in the filing, my clerks would call the justice court and say, who was the police officer? I mean, that's just part of filling in and creating the case. You have to know who the parties are. So, and again, that's our business process.
Okay.
And that works fairly well. There's still some issues about, DAs and police officers. Some of the DAs don't want to know about those, so I can't speak for every county. And on the topic of filing fees, the filing fee itself is not a bar to access to justice, because anybody can file a fee waiver in deferral when they file a case. It's only fair that people that can afford to pay those fees. But we generally approve a lot of fee waivers. So from an access to justice point, the court is already doing its job, determining who should pay and who shouldn't pay. And I think that's an important consideration to keep in mind, because if you completely remove the filing fee, you are going to open the floodgates.
Moving across, thank you. Moving across the top of my screen, I have Jordan and then Lindsay.
Thank you, Justice. I just want to say I find it troubling when we're talking about the filing fee as a deterrent to somebody exercising their rights. And you have a right to appeal these cases. If we're talking about the filing fee as an administrative fee that we need to actually, do this, and from the court's perspective, and I understand what TCA Powell was saying, that's, I think, a different question than if we're saying, well, we need these filing fees to keep people from filing appeals because we don't want to open the floodgates to a whole bunch of appeals. I think that's a very different proposition. I wonder if there's any way that we can figure out whether or not there are a whole bunch of cases out there that would be appealed but for the filing fee. I can't think of how you would find that data, but it just occurs to me that when we're talking about this kind of hypothetical slippery slope of huge increases in the number of appeals filings, it would be nice to have something other than the kind of anecdotal, I think it would, I think it wouldn't, to back that up. Thanks.
And Lindsay.
On the service issue, I wanted to add that, currently the circuit court receives the whole record from the lower court because we're not receiving the notice of appeal. And it would work differently if the original notice of appeal were filed in the circuit court, because the circuit court would have way less information about the case and wouldn't have the full record at the time the notice was filed. Just wanted to add that piece.
Until in your second process, there would be that delay, because if the notice went to the circuit court would reach out to the local court, and the local court would have send the file, and that's the time when you would have the information, all the information in the justice court. Okay. Lots to still work.
Justice Duncan?
Yes.
I was just thinking about the question posed. Is there some way to gather data on what the effect of not having to pay a filing fee has on the number of number of appeals filed. I don't know if it would be possible, but since there's no filing fee in misdemeanor cases, I wonder if we could determine what is the rate of appeal in misdemeanor cases compared to the rate of appeal in violation cases.
I think.
That's a good point, Jim. Oh, sorry, Heather.
Excuse me, Jordan. I think that's a good idea, but I also think we have to remember too that the stakes are higher in a misdemeanor case, and so maybe a person might be more likely to exercise their right in that context where they potentially face incarceration versus a fine.
Jordan, and then Justice Kidd.
Thank you. Just quickly, the other thing I think we might be able to look at is where there's a fee waiver filed that's denied as to whether or not that appeal is pursued. That might give us a clue.
And then super briefly, actually, I think that would be hard to find because I think all the fee waivers are granted. Like I've never seen a fee waiver not granted in Marion County. But what I wanted to say was, here's my real worry, right? Like in this county, the DA just stopped filing misdemeanors altogether because of the appeal statute and how that works. So Justice Court stopped being a viable tool to help the justice system out because of the way that the DA felt that the appellate statute was working. So my worry is if we tinker with the process in a way that creates a whole bunch of appeals, then justice court stop being a useful tool to help the whole system work in general. So.
All right. In the remaining time, we need to move on to our what types of cases are appealable. So these are sections 15 through 18, and then we have stays at 21. Want to flag issues for folks. The first section is on the writ of review. And the recommendation basically is to not do anything to change that substantively, but for our drafters, I would point out that the existing statutes actually specifically cross-reference the writ of review statutes, which I know we're trying to make things as clear as possible and not send people all over the code. But I think here it needs to be clear that the challenges we're talking about are limited to the writ of review challenges. And so a cross-reference to the writ of review statutes should probably go in section 15. Hopefully that's all I have on section 15. And then I'd like to just talk about section 16 through 18, talk about what types of misdemeanors and violations are appealable. And we have a very helpful memo from Jimmy Brewer, who's reviewed this. And I think what we can explain what we were trying to do here is clarify what actually is appealable from the Justice Court to the Circuit Court. In the drafting, we imported the same sorts of provisions that exist for appeals from circuit courts to the Court of Appeals. And Jimmy's memo goes through and says, well, that'll work for some things, but it won't work so well for other things. And so he's thoughtfully done that. If you haven't had the chance to read the memo, I encourage you to do so. He definitely flagged some issues, which I'd like to call out to get some feedback on. But also we welcome feedback after if you haven't had the chance to digest the memo yet, after you have. But Jimmy points out some things. Right now, we all know that when you go from your local court to your circuit court for an appeal, it's de novo. The question is, what happens in guilty plea cases? So let's say you have a guilty plea case that's adjudicated at the lower court, but there is an issue about the legality of the sentencing. And in let's say a misdemeanor case, and the defendant wants to appeal just the sentencing issue. Right now, there's no clear process for how that would be handled, if it's even appealable. So does anyone have any thoughts on what is currently happening in your courts when people want to appeal from sentences only? or just generally about appeals following guilty or no contest pleas when the issue is the legality of the sentencing? I see, Justice Kidd, you have your hand up.
Yeah, I think this is a vast improvement, actually. I like the clarity. I do have people occasionally appeal because they don't like my sentence. And then what happens is they get a whole new trial up above, which is weird. And so I think that this is better. My proposal is that we keep what we do with, that we have with the appeal of just the sentencing, and also have similar language around default, because I think we have similar issues around default, right? If the default's clearly erroneous, there should be a mechanism. But I think that there should be some cabining of what could be heard off a default case.
And I don't know that we have anything in the existing statutes that specifically addresses default. So I think.
Well, there is. There's provisions that have to do with no appeal for want of an answer. And there are provisions that have to do with you can't add a claim or defense. So read together, I think that already exists in the statutory code, and I'm afraid we'll miss it.
In the draft, we're missing in the draft.
Yeah, it's not in the draft. It is in the current code.
And on the defaults, you are saying perhaps a parallel process where just like you could appeal the sentence, but only the sentence, just like it would be from a guilty plea in the circuit to the Court of Appeals, be the same from the local court. That, just to spell it out for everyone, when you get to the circuit court, it would just be a resentence. It would be a resentencing because there's no review of the sentence without the record.
I think it might be a question of, was the default lawful? Is on its face, is the default compliant with the law? And if so, send it back to the Justice Court.
So I see hands, Judge Brisbane and then Heather on the guilty no contest pleas and appeals of sentencing.
On who can appeal, on the issue of who can appeal, justice courts have a statute 157.020. It's unclear to me from reviewing the draft if that was incorporated into the new language. Maybe whoever drafted this knows if they incorporated 157.020. It's definitely different language in the draft than in the current statute. So is the plan to vacate the 157.020? 157.020 is in criminal actions who may appeal appealable judgments and orders.
No, there wouldn't have been any intent to delete that. I don't know if we have I don't have our cross-reference document up. But Judge Brisbane, is that just, I can try and call it up here. But the substance of that, is that for who can appeal from the defendant's position?
Both.
Okay, all of that should be, none of that should have been deleted, so it should be in the draft.
The wording, if so, the wording's different. It's hard to tell.
Check to make sure everything from 157.
Okay, thank you.
Yeah. And Heather?
Sorry, I didn't know if you'd said my name yet. I wanted to clarify that under current law, the limitations on appealing from a default judgment are only in civil cases. For justice courts, in the violations chapter, 138 ORS 138057 allows appeals in violation cases and de novo trial without any consideration for anything that happened procedurally below. And then I don't think default, this is a little outside my area, but I don't think default judgments are allowed in criminal cases. So it would just be violation cases where this would be potentially an issue, and current law allows appeals from default judgments in violation cases out of justice and municipal court. Oh, I'm sorry, so that 138057 is, that's the chapter on appeals, and that applies, I think, to both criminal and violation cases. But then the chapter on violations incorporates that also. So this is also solidified in the violations chapter under ORS 153121, which incorporates that provision.
So just to make sure I followed, so if there's a default in a violation case, you can appeal the default by going to the circuit court and having a new trial.
I don't think that's correct. I think that it cross-references the language from the civil side, right? So I'm willing to talk with Heather and sort of hash out where there might be a link broken, but it is a mess of a code right now. But the way I read it together, it cross-references that want of an answer language.
Jordan.
Thanks. So I just, on the appeal section 16, I wanted to make sure, and I know there's a note about it at the bottom, but I wanted to make sure we added in a section for conditional pleas.
Yeah.
Also, I think Justice Duncan, I agree with your question about the last sentence of that section. I don't think it's necessary. On the merger issue, like if the case is merged, it's merged, and that's the question. The other thing I think we might need to think about is if someone appeals just their sentence, they're sentenced to jail time, and then the circuit court either just says, yeah, that was the right sentence, or no, but I'm going to sentence you to this much jail time instead. Where do they serve that jail time? Because that's always come up, at least in Lane County, as a resource question.
What would so they appeal the sentence and the sentence is imposed by the circuit court, so it's different whether it would be in the county jail or the
city jail. So it comes up in Lane County because we have Springfield has its own jail, and the municipal court sentences people to Springfield jail. And then I know Eugene Municipal Court pays for, I think, a certain number of beds in the Lane County jail. So it doesn't come up as often for those cases, but it's definitely a resource question.
I'm sorry, Jordan, I missed the first part of your comment, but we pay for beds at Lane County and Springfield Municipal Jail.
Oh, I did not know you paid for beds in Springfield now. Okay.
There'd be a question if there's basically a resentencing, there's an appealed sentence, and then you get a resentencing. If you have an agreement to pay, is that a situation where that agreement should be triggered, or is it that because it's coming out of the circuit court, we shouldn't have to pay? Is there?
Right. Or where does the person do their time? Are they on a municipal bed or on a circuit court bed?
Can we just back up on the sentencing a little, just to make sure that we should get to this question? And so, is it clear to people at all whether you can appeal your sentence in a guilty plea case right now? Is it clear? And not clear whether you can at all appeal your sentence after having pled guilty? Jimmy?
Sure. So under current law, and this is just justice courts, muni courts would be a whole other set of statutes. Under current law, ORS 157010 says you can appeal except where the judgment is given on a plea of guilty. So under current law, as I understand it, if you plead guilty, you can't appeal at all, so you can't get any resentencing or anything like that. That statute's a little confusing to me because it doesn't mention no contest pleas. And it would seem to imply, read literally, that if you plead no contest, then you can appeal, from the judgment, but the review wouldn't be limited to the sentencing. So the current statute is sort of inadequate, I think.
Okay. Do
I
you,
think we,
yeah, go ahead.
That's accurate. Justice Duncan, we've actually modified our plea negotiation practices as a result of plain reading of the statute by circuit court judges to mean that if they do a no contest plea and that ends in a conviction, that those are appealable de novo at the circuit court under current law.
And so do they, when you say appealable de novo, it would be they could not plea in the circuit court and go to a trial at the circuit court?
Correct.
Not just that the sentence would be redone.
Correct. We've had folks appeal diversion cases on a no contest plea, fail diversion, and get the opportunity for a de novo trial at circuit court.
So it seems like one of our questions is should you be able to appeal your sentence? It seems like if you've entered a guilty plea or a no contest plea, there could be an issue about the legality of your sentence. So there should be a mechanism for some appeal there. It's not clear if that it looks like it doesn't exist for guilty pleas, but it could exist right now for no contest pleas. One way that you could have that appeal is the case could start entirely over. And maybe you don't plea in the circuit court. Another way would be you go to the circuit court and all that happens is you get a new sentencing. That might be a little, that would be one way to do it. Does anyone have a sense of whether it's easier to just do a sentencing or whether the whole thing just goes to the circuit court and it starts over?
I sure think it should probably just be a sentencing hearing at that stage. If and I question whether or not we should think about removing the language except where the judgment is given on a plea of guilty in 157.010. Why should it matter? If the issue is the sentencing, the legality of the sentencing, why should it matter in what form the plea was, guilty versus no contest, to get there?
Lindsay and then Jimmy.
I haven't thought enough about this, I'll admit, but I do think that it could get complicated to have just a sentencing procedure in the circuit court rather than the trial de novo as far as what happens after the judgment is entered. And it might conflict with, I believe that we had a statute up at the beginning kind of the concept that talks about how a case, when it's appealed, it is treated like a case in the circuit court that was initiated in the circuit court. So I would want to think through that more because I do think it could potentially be complicated.
And then Jimmy, and we'll end with you for this, but I think because we're running up against our time, but I would like us to pick up and for folks to have a chance to look at Jimmy's memo and how are we gonna, what should we do, and provide some ideas about what we should do with guilty pleas and no contest pleas for our next meeting. So Jimmy.
Sure. So I would say guilty pleas and no contest pleas. I don't know why the current statute treats them differently. That seems to be probably an error and we should correct that. And whatever we do with them, we should do the same thing with both of them. Conditional pleas would go in a separate bucket and we can discuss that next time maybe. Okay. Second, I think, and this is sort of the point I'm trying to make in the memo more broadly, is whatever we're going to do with them, we probably need to write some additional language to make that clear to the circuit court. Otherwise, they're just going to default to going to a whole new trial.
Yeah.
And then third, I would say, I think the approach that this draft took makes sense, which is importing the appealability provisions from a circuit court to the Court of Appeals and trying to mirror those as much as possible. And I think that general idea makes sense. If you enter a guilty plea in the circuit court, you can get review of the sentence in the Court of Appeals, but you can't challenge the guilty plea. I think having that same rule be in place. So if you're sentenced to the Justice Court, you can go to the circuit court, get a new sentencing. And if you still don't like it, you can go to the Court of Appeals. And you're not either worse off or better off by virtue of being in the Justice Court to begin with.
Starting in the Justice. Okay. So we have standing meetings. Krista, our next meeting is in January. We are doing it the second Wednesday of each month is our standing meeting. So am I remember, and Sandy, am I remembering that correctly?
Yeah, the next one is set for the 10th.
Okay, so we'll keep talking about these. So for our next time, please think about appeals from guilty pleas, no contest pleas, conditional guilty pleas. Probation, how much do you see these? What should happen if there's an appeal on a probation revocation case? You know, how should that work? Restitution, similarly, that's something where you just have these later parts of a case that someone might want to appeal. And then amended and corrected judgments, all of which are mentioned in Jimmy's memo. And then the other part of the memo concerns state's appeals. And again, we tried to say that the state's appeals are, the state can appeal just like it could if it was taking an appeal from a circuit court case. But that raises some just procedural questions. And so those of you from prosecutors' offices, it would be really helpful if you take a close look at those sections to see if they will work with your processes. What kinds of issues might a city or county ever want to bring up an interlocutory appeal for, and do these processes need to be modified to enable you to do what you need to do? Great. I'm excited that we're moving on to these, what can be appealed, and I really appreciate the discussions that we're having and everyone's attention to these issues. So thank you very much. We will see you again in January, talking about these appealability issues, and that's all I have. So thank you. We'll see you next month. Bye.